I want to welcome everyone to the 40th meeting of the 46th year of the Rotary Club of Dublin and Worthington. Today's invocation and pledge will be provided by Pete. Pete Barner.
Let us pray. For the higher being that each of us pray to, let us pause to give thanks for our freedom in the USA. Let us remember those 156,000 brave souls who invaded Normandy 77 years ago this week on gold, Juno, sword beaches by the English and the Canadians, and by the Americans at Utah and Omaha Beach. Bless this gathering of dedicated Rotarians who are demonstrating service above self. In thy name we pray. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Pete. At this point, President-elect Steve, do you see any guests?
Let me take a look here. Yes. Well,
yes.
Bill Best.
Yeah. My husband Bill is here.
Oh.
Without a picture, but he's got a little square. He's listening.
Welcome, little square Bill.
Welcome, Bill.
I don't see any other guests except for our speaker, who Joe will introduce later.
Good. And now, Phil, do you want to do some happy dollar?
Okay.
There's another microphone on the table.
Clear. I want to follow the president. Are we up to that? Yes, sir. Okay, we are. Thank you all for being here, especially those people who have made the effort to be online and in person, and our honored, I guess, guest host has arrived and is doing his job as superintendent of the schools. And so to that honor, I present the person who will carry the pot, visibly, and we'll accept those. Happy dollars that are coming your way. As you already heard, those of you who are so kind as to join us by Zoom have already been fined because of your wonderful attendance. And those who are here, are there any happy dollars of people who are in the room first that would like to be known? Besides Trent has already agreed to raise his hand and the pot, which is now in his hands, and will be carrying the pot. So Trent, seated, and so let it be. I look at the crowd here to see anybody else who has decided to raise their hands. Well, I have, and the Sergeant's Committee has decided that indeed they will raise their hand because of those who are here today. And so we will contribute to that pot as soon as appropriate. $1 for each of you who have chosen to be in attendance today. That was a committee of 100% agreement, and so that it'll be. In addition to that, I would like to also acknowledge the fact that one of our attendees tends to want to come in from someplace between 25 and 35 miles to attend. And indeed, as that person does come to our meetings, he, as a giveaway, shares the entire, I would say, geographic beautification tour through his back window in his car. And to that, Alan, congratulations. You will be fined $2 for your kindness and your dedication and your eyes on the road, as opposed to looking at me right now. So if we could do $3, we would, but we won't, so we can only do $2. Having said that, is there any other questions or any other comments, or we have some these from? Yes, oh, brother, obviously. I have Happy Dollars. My daughter is now the minister of a new church in Philadelphia. And so she gets a week off here between churches, and we'll be joining her, and most importantly, my two youngest grandchildren on vacation the latter part of this week. So I hope that's $2. Pardon? I hope that was $2 in for the grandchildren. There's 2 for the grand and 3 for my daughter. See there, I apologize. Thank you. Having said that, I believe that is it. I will.
No, I have a Happy Dollar. I have a Happy
I'm
Dollar.
sorry.
I'm happy that I got a proper set of golf clubs that I already told Teresa about, so that when I go out next time with Rich and Mark Beaver and Dave Hansen, that I won't embarrass myself so bad when the Mike Moulton Memorial gets rescheduled.
Okay, great.
Yeah.
Congratulations. Marjorie?
In that theme, I have a Happy Dollar.
A Happy Dollar coming up.
So on a par 3 last night, I chipped in for a birdie.
Wow. That's absolutely. Just walk right on across with that. That's yes. Anybody else that I'm missing?
I have one.
That Teresa and I, as members of the Sergeants Committee, are soliciting for other sergeants to come forth and be part of this revelry, as well as honorarium to the rest of the club members as they appear. So hands in the air, and we will look forward to any call or any text or any kind of communication to either of us going forward. If not, I'll obviously assign, and we'll go from there. President, thank you very much.
Do we have any particular announcements? Is Kara speaking or interested?
No, I think Zoom's kind of messed up.
Oh, okay. Next week we are going to continue in person. So next week we will be having a lunch, and you will get orders for at least the menu in the next couple of days. And I ask that you respond and indicate whether you're attending and if you are, what you're having for lunch. And Tim, it looks like you have your hand raised.
Yes,
Tim
I
Shear.
do. Thank you, Jim. Good morning, everybody. I want to invite folks on Sunday morning, June 20th. I know it's Father's Day, but we will have our second children's Zoom call with the young people speaking English in Mongolia. Anybody that has younger kids, not 5-year-olds, of course, but children, grandchildren, nieces, nephews, neighbors that wants to be on a Zoom call with these splendid young people in Mongolia. Last time we had 15 kids from Mongolia and just a couple American kids. So anybody that has young kids that want international electronic pen pals, I'll keep mentioning this week to week. It will be Sunday, June 20th at 9:30 in the morning. Thank you.
Tim, do you have any literature about that?
We will have literature momentarily, Steve.
Thank you.
Yes, sir.
I have an announcement.
Joe, do you have an announcement?
I do.
Okay.
Communications Committee will be meeting Monday at 8 a.m. on Zoom. If anybody's interested in joining our little cause to keep the club informed, we'd love to have you.
We will be also holding our installation, and that will be on June 23rd, and it is in person here. I encourage everyone to attend that meeting because it is an important time to welcome in President-elect Steve as our new president and honor several award winners that day. So please make it to that meeting. Here it is a luncheon on the 23rd.
And MJ is going to be doing the installation.
Right. MJ will be doing the installation. So again, installation. Okay. Joe, if you would introduce our speaker for this morning.
I'd be happy to, Jim. Thank you. It's my pleasure to introduce Mark Ditullio, who, warning, I have to tell you, is a very long-term friend of mine, and that should in no way diminish your esteem for him. But Mark is a very experienced bankruptcy lawyer, focusing in consumer bankruptcy and protection issues, and I've found those are very little understood rights and remedies, and we asked Mark to come today to illuminate us a bit on those issues. And Mark comes to us by way of New Jersey. He met a nice Ohio girl and has resided here since the mid 80s now. So we're glad to have him. Take it away, Mark. Thank you.
Let's see. Well, thank you, Joe. Good morning, everyone. Scare my screen here. Just to give you, everybody can hear me okay? Yes? Be a little background. When Joe asked me last Wednesday to do today's 30-minute lecture, I responded that the purported response from Henry Kissinger was when he was asked to speak on political policy for a college class, and they inquired about his Kissinger's availability. He stated if he had the rest of the afternoon to speak, he would be prepared to speak today. If he were to speak for a 2-hour class, he would need 2 weeks at least preparation. And if they wanted a 1-hour presentation, at least a month preparation. So Joe only gave me 1 week to prepare a half-an-hour presentation. And I indicated that to him. And then Joe responded, Mark, I knew Henry Kissinger, and you, sir, are no Henry Kissinger. So be that as it may, I will attempt to fit this presentation into less than 30 minutes. We have, first of all, I did this based on the recent pandemic that we have. So I'm calling this the pandemic of debt. So when most clients see me, they have gone to a super spreader event. And I call those super spreader events death, disability, or divorce. So if my clients have gone from 2 incomes to 1 or 1 income to a half, they're usually coming to see me. I call a death of a business the same kind of thing. We have a lot of small businesses that are struggling, especially after COVID. We must determine first what kind of virus they have here. And in the bankruptcy realm, the debt realm, we have 2 types of debt. We have secured debt and unsecured debt. Secured debt would be your debt with collateral. So this would be your house, your car, where you don't pay them, they come and take your stuff. Unsecured debt is everything else. That would be your credit card debt, your medical bills, your dental bills, because dentists don't repossess your teeth if you don't pay them. And as an example of debt becoming a judgment, we're going to use unsecured debt like a credit card debt. And how do we know if we are sick? Well, we get a bill in the first month from that XYZ credit card company and we don't pay it. Next month we have interest, late charges, and the third month we have the same thing, maybe over limit charges at that point too. So at that point, the big corporations, the big banks will give us a call, have their collection department give us a call on the phone and say to us, how are we going to pay this debt? If their collection department doesn't work, then they will go to their outside collection agency. Of course, our dentist down the block doesn't have their big collection agency, so they will go to a collection department, so they will go to their outside collection agency. The outside collection agency, since they are not the creditor, has to send a letter saying that you have 30 days to dispute the debt. And during that time and after that time, the collection agency is going to tell you things like they are going to take your house, garnish your wages, and take your firstborn. They are going to make that sound like it's going to happen overnight. There's a little secret I like to tell my clients. It doesn't happen overnight. The reason why they're telling you that is because they are on a percentage basis. So if they don't collect from you, they don't stay in business. So say we have a collection agency that's not going to stay in business for very long. And after 2 months, they say, he's not going to pay. So they give it to an attorney. Now the attorney can also send a letter, but they usually just file a complaint and attach that notice to it. You'll know you're getting this because you'll get it certified mail, return receipt requested. That's a little green card you have to sign for. And on the first page, it'll say summons. About 3/4 of the way down, it'll say, at least in the state of Ohio, that you have 28 days to respond. And if you don't respond in that 28 days, a judgment can be taken against you. We call those judgments, if you don't answer, a default judgment. They're just like any other judgments, but just like there's a default answer on your computer, which takes what's before as true and correct unless you tell it otherwise. We say default judgments take what was in the complaint as true and correct since you didn't tell them otherwise. Now there's a judgment. Now and not until now can they do something. I usually pause at this point for my clients to let them know that I'm saying something important and to wake them up. So what can they do once you have this virus? What is the virus going to do to you? Well, the first thing the collection attorney is going to do is he's going to put a lien on any property you have in the county. So this would be your real estate that you have in the county. Now, if you have real estate in the county where they filed, then they can put that on there. And they are good for 5 years. They go dormant after 5 years. They can be awakened or renewed every 5 years. But if they got it in the wrong county, so say if they got it in Delaware County and you have real estate only in Franklin County, they can have it certified over and it would have the same effect. Then the attorney is going to look around to see whether you have any property in the county and have any mortgages that are on the property to see whether it's worth it for them to take the next steps. And they may even go get a title search done, which usually takes 1 to 2 months, depending on how big the county is, to see what other mortgages or liens are on the property. Then they file another complaint and you have 28 days to respond. And then a week to 2 weeks to figure this out with the mortgage holders. And then they get an appraisal. The appraisal is usually a drive-by appraisal. So they drive by the house, they say, yep, it's still standing. And they usually use something close to the auditor's value that's of record. Then it's advertised for sale for 3 to 5 weeks in the newspaper. And we call this long, arduous process a foreclosure proceeding. Now, it's not something that the attorney is going to do. Is he do like a finish out of the money, especially since he's advancing the court costs here and is on a percentage basis like the collection agency. However, he will put the lien on because if you go to refi or to sell the house, that lien would have to be paid. So he needs to change this piece of paper into actual money. So he's going to call up his client and say, has this person ever paid you before? And if the client answers yes, he'll say, would you read me the name of the bank and the account number off of the check or other payment? Armed with that information, the attorney will go down to the court and have an order issued to the bank to say, we have a judgment, please take all the money out of their bank account to pay the judgment. And the bank gets that in the mail and they say, okay, and they send it into the court, who sends it into the attorney, who sends it into a client. Then the bank kindly writes you a letter that says, oh, by the way, 3 days ago, they took all the money out of your bank account. Of course, you're calling the bank before that because you have direct deposit and you wrote that check to Kroger and they said, oh, your check is rubber like our picture here and has bounced. And then you call up your bank and you say, what did you do with my money? And they say, well, they took your money and if you didn't get my letter, it's sitting here on my desk that there was this judgment that was taken against you. Now, if Kroger says all these bad things they're going to do to you because you bounced the check, that's okay. I can get rid of Kroger in a bankruptcy. However, if you get a letter from a prosecutor saying if you don't make the check to Kroger good in 10 days, they will have criminal charges against you, I can't get rid of that in a bankruptcy. So when OJ had his latest foray or former faraway here, and he said, hey, can I get him out of the criminal charges he had? I said, no, that's a criminal charge. Bankruptcy doesn't get rid of criminal charges. You need a good criminal attorney, which he obviously didn't get because he was convicted of stealing his stuff back. Anyway, so to keep in mind that bankruptcy doesn't get rid of criminal charges, and bankruptcy also doesn't get rid of liens. And if you listen to nothing else that I say today, remember this point. Bankruptcy doesn't get rid of liens. It does not get rid of liens. It gets rid of debt to the extent they've attached to property. Okay, bankruptcy doesn't get rid of liens. It only gets rid of debt to the extent it attaches to property. And I want you to remember that today, because that's my main point. Okay, and you kind of knew this. You knew that a person who filed bankruptcy doesn't get to say, hey, I don't have to pay on my house anymore, and I get to keep it. Well, we call that type of lien a voluntary because you voluntarily signed it. A judgment lien is an involuntary lien because you didn't want it there, okay? Another type of lien is called a statutory lien. That would be your real estate taxes. And as a general rule, bankruptcy doesn't get rid of those things. You're still going to have to pay for them. However, I can get rid of the other types of debt. So bankruptcy doesn't get rid of liens. It gets rid of debt to the extent it attaches to property. And my clients are usually smart and they know that they shouldn't put more money in that bank account so the creditor can attach the bank account and take more of his money so he can bounce more checks. So the attorney knows it's a one bite at the apple kind of thing. So he's going to go to his next and usual way collect on a judgment, and that's called garnishment of wages. Now notice what I said and notice what I didn't say. I said garnishment of wages or commissions. I didn't say Social Security. I didn't say disability. I didn't say unemployment. So garnishment of wages or commissions are the only thing that you can attach in this state. And you'll know this is going to happen because you'll get a 15-day notice which says within the next 15 days, please send in 25% or more of your pay. 25% of your pay, your net pay after taxes. And if you don't do that on the 16th to the 45th day, this will go to your employer and they will take it out of your paycheck. Now, if you have 12 creditors with 12 judgments against you, because this doesn't happen unless there's a judgment, the most all of them get is 25%. So if we do a little math here, 12 times 25% is a heck of a lot more than 100%. So it can't be 25% each. It must be 25% total. So the most they can get into your pocket for is 25% of your wages. You always get to keep 75% in your pocket. And there's two exceptions to this. And the first one we talk about, this is the first shoe dropping, is you don't even have to pay that 25% if you ask for an exemption hearing, go into the exemption hearing and bring in your paycheck and say, Judge, look at my pay stub. I'm making minimum wage or less. It's federal minimum wage or less. And the creditor should not be able to take the money out. The judge will say, yes, you're right. Legislature has said you make minimum wage or less, you're going to quit and go on under unemployment. And so then we have to pay for you. So creditor come back when the person's not working at Walmart anymore. Or you say to the judge, here's my pay stub. Look, I'm paying spousal or child support of 25% or more of my wages. And the judge will say, yes, you're right. The legislature has said that we'd rather this go to ex-spouse or kids. So come back, creditor, when the kids turn 18. So that's the one shoe dropping where you don't even have to pay the 25%. The next shoe dropping is where I know I just told you that the most a creditor can get into your pocket for is 25%. There is one creditor, however, that's not limited to that 25%, and that is any king. So this is city, state, or federal government. Some of them don't even need a judgment to do that. And this is the Willie Nelson scenario. Remember Willie, when he decided to turn pop singer and got really famous, he decided that he didn't have to pay the IRS anymore. And the IRS said, yes, you do, Willie. Now we're going to take all your stuff. And he had to pay them back, and he made the IRS indeed do that. Because I've seen them take 75% and leave the person 5% to live on the IRS. So that usually gets my client's attention. So we know all these bad things that this virus is doing to me. So what are the remedies that we can do? So I'm going to go through remedies. I usually consider the remedies the smallest to the biggest. And the first one we talk about is a home remedy. It's called a workout. So this is anything you work out with your creditors. An example I use for this is if I have $10,000 of unsecured debt without collateral, and I go to my dear twin Uncle Vito and I say, Uncle Vito, can you give me $10,000? And he says, I'm not a good enough nephew for that. However, I'll give you half. And with that money, I go to all my unsecured creditors and I say to them, hey, how about if I pay you 50 cents in the dollar and we forget about the other 50 cents? If that happens and the creditor does that, fine, I win and I don't have to worry about my virus anymore. However, the creditor usually only negotiates on the charges that are on the bill. They're not going to cut into the principal. And if I get one creditor that says they want 70% or 100 cents in the dollar, and this is all the money I have, then I'm not going to be able to do this. And that creditor will probably race to the courthouse and try to do all those bad things we said before. So say we only have one creditor that's unsecured, and they say, fine, we'll take the $5,000 and we'll forget about the other $5,000. They are under an obligation to send in a 1099 form to the IRS saying, congratulations, that forgiveness of debt, that $5,000 is now your income. So now you have to pay the IRS the tax on $5,000 of that amount that was forgiven. Now, granted, paying the tax on $5,000 is substantially less than paying the $5,000. However, if this is the only money you have, you want to hold enough back to pay the IRS, because if Uncle Vito's not bad enough, who's going to break your kneecaps if you don't pay him, as we've seen, the IRS can be just as bad. So what do we do for if we have a different situation? And the next one I call treatment through credit counseling services. Credit counseling services are a little bit bigger stick. They are nonprofit agencies that look at the person's income and debt, and they say, yeah, really they don't have enough money to pay this, and you do a budget with them, then you pay what's ever left over to the credit counselor, and the credit counselor gives that to all your unsecured creditors. They will only deal with your unsecured creditors. They will not deal with your secured creditors. They usually have agreement with especially the big creditors, to pay no or lower interest rate and no late charges. The creditor, however, cannot agree to this. They usually do, and they can race to the courthouse and do all the bad things we said before. There's no IRS tax liability here because you're paying all the debt except for the interest and late charges. So the next remedy we have is usually through the legal system, and I call this urgent care. We're now going to a doctor. You might have heard of businesses being in receivership. Individuals go to trusteeships. So you qualify for this if you got one of those garnishment notices in the mail. And what you do is you voluntarily take 25% and you pay that into the court, and they distribute it to all your creditors, not just the one who has the judgment. The advantage of this is this gets out to all your unsecured creditors, not just the creditor who has the judgment. And it then can save you from having other creditors take your money through garnishment. The disadvantage of this is that they can do the other executions. They can foreclose on your house and they can take your bank account. So we're really sick now and we're going into the hospital. And I call the hospital the federal system. And the first one we talk about, the first type of bankruptcy we talk about is called a Chapter 13 bankruptcy. My clients like to wrongly call this a Chapter 11 or a reorganization or a wage earners plan. You don't need wages for this. You just need regular monthly income, but my clients like to call the Chapter 13 a wage earners plan, so we'll call it that. And what this is we sit down and we do a budget for you. Whatever we have left over, we pay to the trustee. We do that over the course of a minimum of 3 years and a maximum of 5 years. And whatever we pay, and whatever we don't, we get rid of, or what we call in the bankruptcy realm, a discharge. So again, if we look at number 7 here on the slide, if I had $10,000 worth of unsecured debt, and I have $100 a month, and I go for the full 60 months with charges and everything, we'll just say it's 50 months to make it easy. So 50 times 100 is $5,000. So the trustee will then pay out 50 cents in the dollar to each one of my creditors. So the creditor is owed $100 gets paid 50. The creditor is owed $1,000 gets paid 500, and I get rid of or discharged from that other 50 cents on the dollar. And now you might say, well, that's all fine and good for my unsecured creditors, but what happens to my secured creditors? Because before you said bankruptcy gets rid of debt, it doesn't get rid of liens to the extent they've attached property. So the example I use for this is, say I'm paying $500 a month for my house mortgage, and I'm out of work for 2 months, so I'm behind $1,000. I tried to work with the mortgage holder. They would not work with me. And so I say, I'm going to file a Chapter 13 bankruptcy. So every month I can pay the mortgage payment to the trustee, and we call that a conduit payment, and he will pay that to my mortgage holder. So I can't get further behind and keep the house. I need to pay that monthly amount to the trustee, who will then pay that out to the secured creditor, my mortgage holder. Now remember, I have that extra $100. So in this perfect world of mine, I'm paying the $500 plus the $100, or $600 monthly into the trustee. In this perfect world of mine, the trustee is going to use that extra $100 in the first 10 months to pay my arrearage on my house. Now I've paid my arrearage on my house, and he's going to use the rest of the money to pay that $10,000 of unsecured creditors. So now the unsecured creditors are not getting paid 50 cents on the dollar, they're getting paid 40 cents on the dollar. And at the end of the day, I'm caught up on my house, and I don't have to pay the rest of the unsecured amount. I am discharged from it, and I can go forth and sin no more. When I file a Chapter 13 bankruptcy, the creditors are stayed from calling me on the phone, writing me letters, sending this to collection agencies, filing a lawsuit. If they filed a lawsuit, from garnishing my wages, further garnishing my wages, taking my bank account, and as you've seen, from foreclosing or further foreclosing on my house. And that's why most people use a Chapter 13 bankruptcy. This is a federal remedy, and it requires that you do go to credit counseling before you file bankruptcy, and get a certificate that you went there. And we call that the ticket in. And then in order to get discharged from your debts, you have to go to a financial course for a 2-hour financial course and certify that to the court. We call that the ticket out. It's a lot of information. So I give a summary to my client. And I say, it's in red there on the slide, is that you're giving up a percentage of your future income to get rid of your creditors. The next remedy that we have, and this is basically chemotherapy for our case, is called a Chapter 7 bankruptcy. My clients like to call this a bankruptcy, a straight bankruptcy, liquidation bankruptcy, or just merely a bankruptcy. These are both bankruptcies, but they like to call it that, so we'll call it that. And we'll start with the summary. This is, you're giving up property beyond exemptions. I'll explain to you what exemptions are in a minute, to get rid of your creditors. Whatever debt you have up to the date of the filing, you get rid of. In exchange for that, you have to give up property beyond exemptions. But you're free to get new debt the day after that. You're free to get new property the day after that. You're free to hit the lottery the day after that, and you get to keep all that money. There is only one exception to that, and that is that if someone dies within 6 months of your filing of the Chapter 7, the inheritance money would come back into the bankruptcy estate. This prevents the deathbed filing. So this is the case of Terry Shrivo, if anybody's old enough to remember who she was, where your mom's on life support, you're going to get a big inheritance, so you want to get rid of your creditors before you pull the plug, and that money that you get on the inheritance would have to go back into your bankruptcy estate. They don't have to give you the inheritance within that time. They just have to die within that time. So this seems like a great deal. I can go out and get new debt and new property. But what do I have to give up? Well, what you have to give up is property beyond exemptions. You say, well, what's exemptions? Exemptions are property that you get to keep. There are 5 pages of it with very small print. I will give you an example of what exempt and non-exempt property is. For example, there's a wearing apparel exemption because the trustee is not going to take the clothes off your back, because if you have no clothes, you'll have indecent exposure. And then you'll have criminal charges, which you can't get rid of in bankruptcy. So therefore you get a wearing apparel exemption. You get to keep your clothes. However, if any one of your items is over more than, say, $525, then you would have to give that up to the trustee in a Chapter 7 scenario. And that's the example I have over there. So say I have a fur coat, it's worth $5,000, a very expensive fur coat. I would have to give that up to the trustee. In this perfect world of mine, he would use that, he would sell the fur coat and pay my creditors 50 cents on the dollar. I don't have to worry about how much they get. I just have to worry about giving up the fur coat. And now, if anyone's still listening, if you heard what I said before, is that what happens to my secured creditors, because you said bankruptcy gets rid of debt, it doesn't get rid of liens. So do I have to lose my house in this case? And the example I give for your secured creditors is you have a choice of doing one of two things with that secured creditor. And I'll use it as an example, a car. So say I have a car and it's worth $5,000 and I owe $10,000 on it. I can do one of the two things with this. I can say, oh, that car's a lemon. It's always been a lemon. Let him take the car back. And I give up the car. They take it, they sell it for $5,000. The deficiency balance, the difference between the $5,000 and the $10,000, I get rid of that, just like I got rid of my credit card debt, and I don't have to pay it. Now I say, I like my car, I want to keep my car, so I want to do a reaffirmation agreement. I don't care that I have to pay $10,000. So a reaffirmation agreement is a voluntary agreement between me and my creditor that I'll keep on paying, just like before the bankruptcy. And I do that, but I don't pay it for 60 days, because 60 days I can rescind this. And now the creditor comes and takes my car and sells it for $5,000 and comes out after me for the difference between the $5,000 and the $10,000, because I affirmed again, hence the prefix re, on that car. And that's the example we have there. Again, there's a stay that goes on to stop your creditors. Again, this requires a certificate of credit counseling before and after. And you'll see there that unlike the Chapter 13, a reaffirmation agreement is a voluntary agreement, where in the Chapter 13, I can actually force them to take that over time. And that's the basic things for bankruptcy. I'm a little bit over my time, but here are some things that are exceptions to discharge, and that's basically personal income taxes that are under 4 years old from the tax year, divorce debts, criminal orders, fines, penalties that we went through before, DUIs, death or personal injury from intoxication, student loans. Although there's an exception to student loans, if the debtor can prove undue hardship. There are certain debts that are not automatically not accepted from discharge, and those would require the creditor to file a lawsuit, and basically they're listed there. And they're basically fraud or embezzlement or willful injury. So that's all I have. I'll be more than happy to entertain any questions from anybody. That's me when I had more hair. We have any questions? If not, I thank you for your time. And I'll give it back to the speaker.
I have a question.
Okay.
Mark, can you hear me?
Yes.
Yeah. So I heard you say, if a judgment is made against somebody, that they can then go to the employer, right, and garnish their wages. And as an employer myself, I start thinking about, well, how did we get in the business of providing healthcare and then 401k and pensions and all this stuff? So I don't know if there's a good answer to this question, but at what point, did the employer get involved in what should really just be a matter between two individual parties?
The big places have this happen all the time. I actually had one client who was in a smaller place, and she was the one at the company that actually was taking the money out of her paycheck for the garnishment. But the garnishment amount is 25%, and you send it in after you pay the person's taxes. You don't take you take the benefits out of the rest of the 75%. Is that what your question was?
Well, I think it was more around just like over time, I'm sure some legislative bodies said, well, let's just go straight to the employer and get the money that way. I mean, maybe I'm sour grapes here, but it just doesn't seem really fair to the employer to even be involved.
And some states agree with you. some states don't agree with me. It does not. Some places, when I was a younger lawyer in different states, they said it's illegal to have a garnishment of wages in this state. Some places will only allow it after if the pay was due 90 days from there. So that's like if a teacher would have the pay withheld for the summer. They would only allow attachment of paychecks that were due 90 days later. But no, you can get, just like you can get your bank involved, you can get the employer involved if there's a judgment. So the moral of the story is don't let your unsecured debts go to secured debts. And that's kind of why I tell my clients that this whole how a bill becomes a judgment kind of thing is that what kind of remedy you're going to need. But yes, Ohio is known as a creditor state, which makes I represent creditors, some of my creditor clients very happy about that. Any other questions? No?
Yeah, we got one more here.
Yes, I have a question. I'm just wondering what percentage of our population actually files for bankruptcy? I mean, is this a common occurrence? And if it is, do you see it more frequently with businesses as opposed to individuals?
So that's an excellent question. So the Bankruptcy Reform Act that was put in several years ago was instituted by creditors, representatives in Congress. And it was, bankruptcy actually only comes to about 2 to 5% of actual credit card debt, unsecured debt nationally. However, the credit card companies convinced Congress that this was much more than that. And it only happens because of those 3 things that I said before. So no, it's not really large. It's not, compared to the amount of credit out there, it's very small amount of people that are actually filing bankruptcy. People in this country feel a moral obligation to pay their debts. And they don't want to file bankruptcy. So coming to me, I always say, is like going to the undertaker. Nobody wants to see me. So I have a bad reputation, I guess. Anyway, as far as small businesses, so I'm usually not so you know that the economy is cyclical. And I'm usually not at the valleys or the peaks very busy, believe it or not. I'm usually in the transitions. I'm busy. So when the economy is starting to get really good, I have a large amount of consumer clients that come in, and that's because they're getting a divorce or something like that, and you know, they've gotten credit and they're overextended on credit. And when the economy is going down is when I get the small businesses. And that is because, you know, they have a bad Christmas or something like that. So they're, you know, they can't survive it anymore. And then they come in and they see me. But I usually at that time when the economy is going down, people don't extend themselves on credit a lot. I say, you know, people are fairly smart about their finances, contrary to what the Congress believes about consumer debtors. I hope that answers your question.
Yes, thank you.
Okay. Any other questions? Well, thank you very much for having me.
Thank you, Mark. That was highly informative. And while any of us do not want to look forward to having to meet you in the future regarding bankruptcy. So, see if he has an opening at 2 o'clock. Okay, Jerry's asking for an opening at 2 though, so. So with that, I think we will go ahead and move to adjournment and the reciting of the 4-way test. Again, next week will again be in person for lunch here. So please do respond to the email regarding whether or not you're attending, and if so, what lunch you would like to order. So for the 4-way test, we have everyone standing here. Good. The things we think, say, and do. First, is it the truth? Second, is it fair to all concerned? Third, will it build goodwill and better friendships? And fourth, will it be beneficial to all concerned? Again, thanks for attending today, and hopefully we will see you next week and in person. Thank you.